Well, let us get back to the discipline, the core issue arising. Refer or not refer? Should it be reference and why reference? That's the query my Lord put between. I think my Lord the Chief Justice put it. In fact, Justice Shah and Justice Narasimha also put it. Was Nabam Rebia the basis of their case? Was it the basis of the order? Was it the basis of the entire litigation? Now, Mr. Jethmalani tried to address the issue directly today morning. And perhaps he has not been rightly advised. His clients have made repeated averments directly to the contrary. Every argument of my learned friend is belied by in writing pleading. My learned friend has showed one letter to your lordships. Just note in sequence, the lord should be astonished how much entirely reliance on Nabam Rebia, which is why your lordship will refer it, unless your lordship wholesale agrees with Nabam Rebia, obviously. If your lordship doesn't agree with Nabam Rebia, it has to be referred. Now, kindly note that. Just note the pages first to save time, then I'll show the pages. My learned friend, with great respect, has made an oral argument without being advised about his own client's pleadings, or at least his related client's pleadings. PDF 160, I'll give all the PDF first together, so Lordship will be able to follow it more easily. PDF 160, this is all in compilation CC1. That is not case law compilation, but the main CC1.
CC1.
Pleadings.
Convenience compilation.
Yes, CC, convenience compilation. Now, remember, your Lordship is considering only two issues. A, are you agreeing with Nabam Rebia or not? That your Lordship has already heard on the merits first. These are the errors of Nabam Rebia, they are the problems, they are the consequences. The other is, Nabam Rebia is only a casual, marginal, possibly inconsequential basis of the other side's case. In which case, even if your Lordship disagrees, why should your Lordship refer it? Number, this is completely, I'm astonished. Now turn to Bullis 160. My Lord has got 160, there's a PDF page. The para I'm referring to is Romans 17. This is how we came on 24th, 25th, 27th, etc. of June.
What is this page 160 that you are reading out?
I am reading 160.
What document?
The actual petition.
Sorry?
It's part of the writ petition.
It's the writ petition by which the whole thing was born. Whole thing started, and this is what we argued.
Writ petition filed by them.
On
which 27th order was passed.
On which, and that's the foundation, there's the main Shidde petition, if your lordship may so call it, on which everything is founded. That's 160, I'm sorry. It's a short paragraph. 34 MLAs of Shiv Sena issued notice, including few independent MLAs, issued notice under Rule 11 of the Maharashtra Assembly, read with Article 179 of the Constitution to the Deputy Speaker, Mr. Zirwal, to move the motion for removal from the office of Deputy Speaker and requested him to refrain from discharging the functions from immediate effect. A true copy of the translated notice of 21 June, etc., for his removal is annexed. Now, there is one important point here. I did not say it until I showed the page. Along with this reliance on Rebia, which I will be developing in a minute, is a major suppression. Major suppression. And both suppressio veri and seditio falsi, both aspects also. Your Lordship heard hardly 1 hour ago that nothing turns on this because this was rejected. Your Lordship heard it just now. Where is the rejection mentioned here? You have come to a court in a vacation seeking urgent interim relief involving the possible toppling of a government. Today, because it suits you, you argue that it was rejected. Now the whole para is here. Lordship will look behind and forward. There is no mention of rejection. It's completely suppressed. Now go on. Kindly proceed further. Now come to 174. So, there is a remarkable intersection of suppressio veri, seditio falsi, and reliance on Rebia. It will just, when I complete, you will see the total picture. And it's true in constitutional adjudication, we can have very large, nice issues, but ultimately, there should be some discipline of law. How you came to the court, what you relied on, today your Lordship is considering reference, not the merits. 174. Oh, sorry, 167. My apologies. I gave the wrong page.
That specifically refers to Navam Rebia.
Yes. Now comes the ground, the first ground. No, see the whole construct, the basis on which you came, you entered the door with this basis, got an order, and today because Navam doesn't suit you, you are being disloyal to Navam and detaining it. The petitioner is filing the present writ petition on the following amongst other grounds which are taken in the alternative. First ground. First, Deputy Speaker cannot disqualify any member under Schedule 10 during the pendency of his own removal resolution because this Honorable Court in Navam, so-and-so, 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 has held that the Speaker or the Deputy Speaker during the time of the pendency of a notice of resolution for removal cannot disqualify any member. The relevant paragraph reads as follows. Now we have harassed your lordships enough time in this paragraph, but look at the length of the quotation. This is the writ petition's first ground. This ends at 173 after 3 pages, entirely same paras we have read above. Paras are the same. But no disclosure of rejection. The title is when a resolution for removal of his own removal is pending. Mark the word pending. The next sentence should be, oh, but yesterday it was rejected. Your lordship should know that. The word pending is used, own removal is used. This is a suppression of the worst kind. Now, it's not just, I remember, I'll give you a citation. There is 1976 judgment of the lordships. Take out that. Which cites 64, just a digression for a minute, lordship will see what standards the lordship is to maintain. And it's all right, your lordship is crowded today, so your lordships always can't maintain it. 76 Supreme Court cites 64. In 64, Mr. Settleward appeared. I'll give those 2 citations to your lordships. And it was found that one of the grounds in the SLP was false or wrong. Misstatement. So Mr. Settleward appeared second time and the judges agreed with him and he said, I never argued this ground. It is a misstatement. I never argued the ground. And he says, we will take your statement, Mr. Settleward, as correct. We did not grant leave on the basis of this because you never argued this ground. But we will revoke leave. Because there is a misstatement. Now this misstatement is the basis of getting whatever order you got on 27th.
On 27, according to them, there was no injunction.
No, kindly see, on 25th or 26th or 27th, would the speaker have disqualified or upheld and said no disqualification? Just can you go step by? This is very important. This is the biggest fiction being propounded to your lordships. Suppose there was no order by the vacation bench of this court. Just for a minute, efface the slate clean. The speaker would be at liberty on that day, which is the 27th, to either disqualify XYZ or not disqualify. The speaker had given them time till 25th, so his hands are free till 27, 2 days. Your lordship does it frequently, as I appeared for 2 hours, matter went until 9 o'clock in the night. The learned judge said that the effect is the same, we extend the time and we'll be hearing the matter. When your lordship extends the time to file a reply, can the speaker decide? Stays or interim intervention by lordships has many forms and models. They come in myriad colors. It's completely a stay. I am repeating, I was there for 3 hours and 2 days. Only Navam was argued. Only Navam was read. Now you can today say anything, and possibly, there are video recordings of the hearing. It was argued in the evening, till 9 o'clock. The learned judge sat from 5 o'clock. I mean, we can disagree on Navam, but we should not say that Navam is not the basis of your case. This is highly troubling. This is wrong. This is not the tradition of this court. Now, your lordship has extended the stay for filing, the time for filing reply, the only effect of which is the learned speaker's hands are tied. He can't do anything. And then the judge says, the learned order says, in the interim, and then he says, I am hearing it on Monday. This was a Thursday or a Friday. Next Monday I am hearing it. This will take care of it. But kindly go further. Kindly go further. Now your lordship has seen 167. Now come to 174. D. So, Malus, your Lordship is having whatever your Lordship makes of this cocktail of suppression, of Malus misstatement, and Malus of nabab. Whatever your Lordship will see in the overall picture. D for Delhi. That was Malus suppressio vera. This is suggestio falsa. This is a direct affirmative suggestio falsa. Because of the disqualification proceedings initiated against the petitioner is invalid and against the various provisions of the Constitution, as the resolution for removal of Deputy Speaker is already pending for decision, and the disqualification of the petitioner is liable to be set aside solely on this ground. Just because this is Supreme Court. Just because it suits you, you can't say today that it did not have any role, rejected. Over. Finished. That's not your case. Then Malus 193.
190.
And I hate to say what the bench would have said or held had this been told to the bench. That's not for me to speculate and possibly not for Lordships to speculate. 193. Now see the prayer. Nabam was not the basis of our case. Nabam was hardly argued or touched upon. Number was one out of many. Now see the prayer, please. The first prayer again, like that first ground. Issue a writ of prohibition, mandamus or any other appropriate writ, direction or order directing R1 to not take any action on the disqualification petition under Rule 6, seeking disqualification of the petitioners under so-and-so, pending before the Honorable Speaker, state, and not to take any action on the same. Mark the two lines. Until the resolution for removal of Deputy Speaker is decided. Again, of course, that it is, Malus. Now see that written submission, Malus, which is filed now. Now meaning now, Malus, to oppose the reference to Navabrevia. Can you show me that? That is called written submission on behalf of R4, opposing the reference to a bench of 7 honorable judges. Possibly 5 before 10 January, I am told.
There are two. One, yeah, it's there.
Serial number?
Serial number D.